Chief Justice, Justices, as my time today is short, I will paint my picture using broad brushstrokes. As noted in paragraph 4 of the affidavit of Bruce Clemenger submitted with our application, evangelical Christians are an identifiable minority in Canada, representing 12% of all Canadians. Christian engagement in public discourse has greatly benefited the development and life of Canadian communities and the nation as a whole, with admitted imperfections as in any community due to the human condition. We call it our sinful or fallen nature. In this regard, I draw your attention to our Book of Authorities, particularly the items at tab 6, a Church and Faith Trends article, at tab 5, the Christian Witness in a Multi-Religious World document, a document produced by the 3 representative international bodies of the largest confessing communities of the 2.1 billion Christians on the planet. At tab 10, a Christianity Today article presenting, proselytizing in a multi-faith world. And I'll leave those with you. I wanted to highlight them to make sure that you get the full picture. Jesus' command to his disciples, found in Matthew 28, compels Christians to public engagement in word and deed. Jesus' motivation, and that to which he called us, was love of sinner and hatred of sin, separation of the identity of a person from behavior unacceptable according to his teaching. All of this fits within Justice Dixon's descriptions in paragraphs 94 and 95 of the decision in Big M, and Justice Gonche's description in Chamberlain at paragraphs 134 and 135, where he notes the need for a truly free society to permit disagreement with others and even disapprove of the conduct or beliefs of others. Otherwise, claims for respect or recognition or tolerance, where such language becomes a constitutionally mandated proxy for acceptance, tend to obliterate disagreement. Justice Gonche continues by observing that Justice Dixon's words in Big M are the essence of freedom of religion and also the essence of freedom of expression generally in an inclusive, secular democracy. Increasingly, evangelical leaders, pastors, and congregants across Canada are feeling and experiencing that the expression of religious positions on matters of public debate is not welcome. Even today, Counsel for the Saskatchewan Human Rights Commission referenced the reading of Paul on television as hate speech in his opinion. I direct your attention in our Book of Authorities as well to tab 7, The Price of Freedom Denied, that speaks about freedom of religion and persecution of Christians, particularly evangelicals, around the world. Calling opinion leaders hypocrites, whitewashed tombs, or a brood of vipers, as Jesus did, might well subject one to both complaint and conviction under Section 14(1)(b) in today's Saskatchewan. The case law on 14(1)(b) and similar provisions in other jurisdictions paints a checkerboard of application by tribunals and various levels of the courts, displaying an inability to effectively apply the decision in Taylor and evidencing the vagueness and subjectivity of this remedy. Proponents contend that 14(1)(b) has been virtually, although not actually, read down, which bears testimony to an overbroad reach and the chilling effect on freedom of expression in general and freedom of religiously informed expression in particular. My friend from the Alberta Attorney General's office has even recharacterized hate speech as discriminatory expression. There is no defense to Section 14, not truth, not sincerity, or reasonableness of belief. The subjective feeling of offense, affront to one's dignity, or loss of self-respect empowers contemporary penalties that, for the average Canadian, required to retain counsel and be subject to multiple appeals, fines, or both, seem more worthy of an ideologically driven society than a free and democratic society. In Canada, when a citizen shares personal religious beliefs on a matter of public dialogue and does not coerce compliance with those religious views, then the government, by virtue of Sections 2A and 2B of the Charter and prior decisions of this Court, must allow and even protect this expression of religious opinion, not censor it. And those are my submissions, subject to any questions.